are just going to discuss about the discharge or termination of contracts. So this is the last portion, and again there are some sort of remedies with regard to the breach of contract. So regarding the termination and discharge of contract, there are various modes by which a contract can be discharged or terminated. So there are 6 ways you can we'll just go into the 6 modes of this discharge of contract or termination of contract. So one is by actual performance or by performance of contract. Another aspect is by mutual agreement. The third point is by lapse of time. And fourth is by operation of law. Fifth is by impossibility of performance. And the 6th point as by breach. So these are the 6 modes by which a contract can be discharged or terminated. So the first one, as you all know, by performance of the contract. Another is by mutual agreement between the parties. The third is by lapse of time. Fourth is by operation of law. Fifth is by the impossibility of performance. And 6th point is by breach. And regarding the first point, that is by performance. This is, of course, the obvious and the natural mode of discharge of the contract or termination of contract. When 2 parties are entering into contract, and if they are just executing or discharging their duty as per the terms of the contract, if they are performing as per the terms of the contract, you can say that they have discharged the contract by performance. So with regard to the performance of contract, it can be classified into 2. By actual performance, another is by attempted performance. So what is actual performance? As we all know, the 2 parties are entering into contract, and if they have entered into contract, perform the contract as per the terms of the agreement, of course, you can say that that is an actual performance. And what is this attempted performance? Suppose there are 2 parties. Suppose I and Sarah, we are entering into a contract, and I have decided to give some goods to Sarah. And on that particular date, I have just went to Sarah for the delivery of goods. But Sarah has refused to take the delivery of the property. So we can say that, you can know that this particular contract is actually an attempted performance. The other party was not ready to perform, or he was not ready to take the delivery of that particular property, which accordingly to the terms of the contract, then you could say that that is an attempted performance. And for attempted performance, the promisor is not at all liable because he has done his part of terms of the agreement, but the other party was not ready to accept as per the terms of the agreement. So you could say that that is an attempted performance. So with regard to the discharge of contract, it can be classified into 2, actual performance and attempted performance. Then we'll just go into detail regarding the mutual agreement. That is, the contract get terminated or discharged by the mutual agreement between the parties. So with respect to that particular discharge of the contract, it can be classified as novation, then rescission, remission, alteration, waiver. So these are the 5 modes by which a contract can be discharged or terminated by mutual agreement. Novation, rescission, remission, then alteration and waiver. So we'll just go, what is this novation? The word meaning novation means substitution. Novation, the word meaning is substitution. So the original contract is substituted by a new contract. So that can be entered between the very same parties or by different parties. So you should know the difference between all these: novation or rescission or remission, alteration and waiver. The difference you have to feel. The novation is actually a substitution by a new contract. So the original contract or the old contract get discharged. So this novation or substitution of the original contract, substitution, actually it is entered between the very same parties, or it can also be entered by different parties. So either by the same parties or by different parties. So in the case of novation, what is the consideration in the novation? The discharge of the original contract is the consideration for the new contract. So original contract doesn't have any role to play again. So the consideration of this new contract is the discharge of the original contract. So that is novation or substitution. Another mode is rescission. Rescission is the cancellation of the terms of the contract. So that particular contract gets discharged. So there's no new contract, there's no substitution. So the contract gets cancelled, that is all. And regarding the next is this alteration. With regard to alteration, you could say that that is entered only between the very same parties. The terms of the agreement are altered. So the difference between an alteration and novation. Novation can be either by the very same parties or by different parties. But in the case of alteration, if there is some sort of alteration with regard to some terms of the contract, it can be altered only by the existing parties, not by a new party or a third party or different party. Only between the parties of the contract. Another is remission. Remission means that is a lesser fulfillment of promise. If I owe rupees 5,000 to Sir and I'm giving rupees 3,000 to Sir, she has accepted it with full satisfaction. That is remission. Thereby, the contract gets discharged. That is accord and satisfaction. Accord means agreement and satisfaction means performance. So, even if there was a contract between the parties and the parties have accepted to get that fulfillment by a lesser amount or lesser fulfillment of the promise with full satisfaction, you can say that that is remission, whereby the entire contract gets discharged or terminated. Another mode is what we call waiver. Waiver is nothing but an abandonment or relinquishment of the right of the parties. Suppose I'm entering into a contract with the Hari. Then Hari forbids me to perform that particular contract. Suppose I just promised to draw a Ravi Verma painting. And Hari have accepted it. So, but later on, he forbids me from performing that part of contract because he have abandoned or relinquished the rights. That is waiver. So these are the modes by which a contract gets discharged by mutual agreement between the parties. Okay, by novation, rescission, remission, alteration, and waiver. Okay. Then next mode is of course by lapse of time. So as we all know, time is an essence of contracts. So time has a great role to play. Whenever we are entering to the contract, it has to be done within a reasonable period of time if the time is not mentioned. So we all know in the case of recovery of debt, the limitation period is within a period of 3 years. If that particular 3-year period is over, we have no right to sue or no right to recover the property because it is barred by limitation or the limitation period exceeds. So by lapse of time, that particular contract gets discharged or terminated. That is by lapse of time. Another mode by which the particular contract get discharged or terminated is by operation of law. In operation of law, there are four modes. One is by death of the party. Another is insolvency of the promisor. And the third is material alteration. And fourth is merger. Merger. So by operation of law, the contract gets discharged or terminated by either by death of the party. Another is, you could say, by merger. Another is by material alteration and insolvency. Death of the promisor. So with regard to the death of the promisor, if that particular terms of the contract need the special skill and ability of the promisor, then of course death of the promisor would result in the discharge of the contract. But if it doesn't need the skill or the ability of the promisor himself, that particular contract gets continued through the legal representatives. So they could just sue for the damages all. But with regard to the death of the party, especially when the promisor has agreed to do some performance, where there is a skill or his ability is inevitable, such case, if the death would result in the discharge or the termination of the contract. Insolvency is another. Suppose the party or the promisor has been declared insolvent, or if he's adjudged insolvent, is that particular contract gets discharged. But if his insolvency ceases, or if that particular insolvency or the period of insolvency that has been discharged, that particular contract can be continued. Another is material alteration. Whenever there are alteration, that should be done with the acceptance of other party. If the other parties have not consented to it, if the other party have not approved for the material alteration, then the contract gets discharged or terminated. And merger. What is merger? An inferior right is merged into a superior right. I'll just give you an example. If a person have taken the property for lease, so that time he is only a lessee. And later on, what he did is he just purchased the property. Now he is the owner. So there is no particular contract regarding that. There is no lease as such. So an inferior right that as he was a lessee, later on he became the owner by purchasing that property. Then that right gets merged. Now there is no contract as such, and the contract gets terminated. So by operation of law, these are the four ways by which the contract gets terminated: by death, by insolvency, material alteration, and merger. Next is the impossibility of performance. A contract gets discharged by impossibility of performance. If you are not possible to perform, of course, the main thing is that particular contract gets discharged. So impossibility of performance, there are two aspects, that is initial impossibility and subsequent impossibility or supervening impossibility. What is initial impossibility? Suppose a person have entered into a contract where it is not possible to perform. For simple example, if a person have promised that I will discover the treasure by magic, is it possible? So such promises are not possible. So that is initial impossibility. While you're entering into an agreement itself, that is a particular term is what where the performance is not at all possible, then you could say that that is initial impossibility and that particular agreement itself is void. It's not a contract as such. Because that is not, you are not able to perform, that is impossible to perform. So such agreement is void. And next is subsequent impossibility or supervening impossibility. At the time of entering into contract, it was valid and you were able to perform a contract, but later on, some sort of impossibility arose where we could not perform that particular terms of agreement or contract, whereby the contract or the termination of the contract results. Some of the examples or some of the ways by which lead to a supervening impossibility are: